Okay. Welcome, everybody, to John Howard Society Week. This is our second session in a series that we're doing on bail issues. I'm Catherine Latimer from the John Howard Society of Canada. And yesterday we heard basically gave us some idea of the numbers of people who are held in remand centers awaiting their trial. So these are essentially technically innocent people, many of whom are released with charges having been dropped against them. I think the numbers in themselves say a lot, but perhaps more so is knowing a little bit more about those individuals who are having their lives disrupted, why they're in there, what the conditions are like in there, and what we can do as John Howard Society members and others to try and support them in the community on some bail alternative programs. So very happy to be joined today by Safiyah Hussein, who's with the John Howard Society of Ontario. They have a very impressive research component, and they have done some research on the bail system in Ontario. And she's going to share the results of that. And Craig Santos, who's with the John Howard Society of Ottawa and runs a bail alternative program. So Safiyah, would you mind taking the floor? Thank you.
Thanks so much, Catherine. I'm so happy to be here. Let me just set up my PowerPoint here, if you give me one moment. Okay. Is that showing up okay? Perfect. Okay, so I'm going to take, as Catherine mentioned, I'm going to take you through a couple slides today talking about some of the context in Ontario around the bail and remand system. And then my colleague Craig will talk about some more focused programming areas. So I wanted to start off with just going over the reality in Ontario, and some of this might be related to information that was shared yesterday in the presentation for those that attended. But the research and policy work that we did is really focused in on Ontario. So just to give a context of what that looks like. In Ontario, 80% of the jail population is on remand, and this is official numbers, but unofficial numbers that we're hearing are much higher, upwards of 85%. So those inside our provincial correctional institutions are mostly awaiting a bail hearing or a trial. They're legally innocent. 1 in 6 admissions to provincial corrections involve individuals without a fixed address. So individuals, when they're admitted to provincial corrections, are asked for their address, and if they don't have one, they're recorded as no fixed address or NFA. And so this is sort of a semi-indicator of homelessness among the correctional population. And we're seeing that this issue has been increasing over the years. 44% of bail court cases had charges withdrawn or stayed before trial. So that means that individuals are spending time in a provincial correctional institution, spending time in jail without actually having charges that result in longer jail time, or without having ever being found guilty. And so we're seeing a lot of people experiencing the many effects of jail time and later having their charges withdrawn or stayed. And when we're looking at the types of offenses that people are coming into the system with, 28% of cases, this is 28% of all criminal cases received in 2025, were administration of justice charges, had administration of justice charges as the most serious offense. So this is things like failure to comply with a condition, failure to appear at court, and they were listed as the most serious offense that people were coming to the courts with. So this shows that not all of the cases are violent offenses. There's a significant number of cases that are coming before the courts where it's related to people not being able to follow their conditions or appear at court. And this, as I'll touch on later, is often related to complex needs that individuals are facing as they come before the criminal legal system. So this is just a little bit about some of the conditions inside provincial institutions. We're seeing overcrowding. Sometimes it's 3, 4 people per cell designed for 1 or 2. So people are sleeping on the floor, often, next to a toilet, without proper bedding. There's limited access to programming. And this is particularly true for individuals that are in pretrial detention or on remand. They often have shorter stays, uncertain amounts of time incarcerated, and so they often receive limited access to programming while they're there. There's frequent lockdowns. This is often related to lack of staff and other challenges inside the institution, and this impedes access to individuals getting in touch with their lawyer, getting yard time, getting shower time, often inadequate healthcare delivery. So individuals often are not getting the appropriate health care or in a timely manner. And we also see accounts of unsanitary living conditions. So things like, air conditioning not working in the summer, the cleanliness of cells being an issue, et cetera. And often a lot of these issues are impacted by things like the lockdowns, the overcrowding, and the fact that many of these institutions are highly over capacity. So we looked at, this leads us to our report that Catherine mentioned. So it was called Finding Common Ground. And we really wanted to look at the issue of bail and remand in Ontario, but we didn't want to reinvent the wheel. There's been so much work on bail and remand in Ontario and in Canada. But we really wanted to identify if there was an opportunity to bring together some sector experts and look at a number of the recommendations that exist in reports out there and determine if there's any priority areas that we can focus on. What can we do now to improve some of these challenges with the current system? And primarily, what can we do to reduce the remand population? As we're seeing, provincial corrections are well over capacity, and most of those people are on remand, are in pretrial detention. So what can we do to address some of those numbers? And that's what we endeavored to look at in this report. We reviewed 25 academic and grade literature sources that were published between 2015 and 2025. And we compiled all of the recommendations that were within these literature sources and created a survey that kind of categorized these recommendations and asked respondents to rank and prioritize them. So we could get a sense of where individuals felt there was a greater priority in terms of the recommendations that were out there, and allowed individuals to also share their perspectives on what else should be done and some of the strengths and limitations of the current system. Following the survey that we distributed to stakeholders, we also held focus groups. These ended up being with service providers, lawyers, law enforcement, policy professionals from across the province. And this is a bit of a breakdown of the folks that we heard from with the study. This large blue section is police services. So they made up the largest portion of respondents. And then we also heard from social services that included bail workers, other service providers from across Ontario. We had some Crown Defense Council, Duty Council, and others that were often policy professionals from policy organizations or academics, Indigenous organizations, etc. And we had quite a even breakdown across the province. So we had folks from all over Ontario, Southwestern, Central Ontario, Eastern, and Northern Ontario. So that shows the makeup there. So one of the things we asked in the survey was around strengths and limitations of the current system. And these were some of the key findings from there. So the number one is that people involved in the system have complex health and social issues that are not being met. So this is a lot of people are falling through the social safety net, cracks in our social services, needing mental health services, primary health care, substance use treatment, dealing with homelessness, lack of employment, and they're finding themselves wrapped up in the system as a result of those unmet needs. And so we heard this across respondent groups, that they're increasingly dealing with more and more complex needs of individuals. There's also some diverse views around the system. So we got some mixed perceptions of the bail system. There are some respondents that felt that the system is fair and working quite well. Others felt that the system is more of a catch and release system, that it's too lenient. There were differences of opinion when it comes to things like virtual bail court, some noting that it actually improves access to justice because people don't have to be subjected to strip searches inside institutions to appear at bail court. Others talking about how it's an impediment to access to justice because of technology issues that exist in different parts of the province. So there were some different perceptions that were reflected in the responses to the survey, which is notable. One other thing we heard is that homelessness is impacting release. So when individuals are coming before bail court, if they are experiencing homelessness, that often impacts whether or not they can get a release or how fast. And so that's also bogging down the court system. There's issues with collaboration and system coordination, people having to navigate multiple systems and really having difficulty with that, especially if they have a number of complex needs. Court delays in terms of looking at efficiency versus access to justice concerns. And an overall system strain. Like the system is struggling. Everything from police to the courts to corrections are seeing challenges and strain. And these were some of the top rated recommendations that came out from the survey. So people noted that better utilization of the bail verification supervision program. This is a bail program. We'll hear more about this afterwards, but these are delivered effectively by community-based agencies across Ontario, and many of the respondents felt that this was an integral part of the system. Increased investments in long-term community safety was cited as another important recommendation and a focus area. Enhanced interagency collaboration and improved linkages between police, courts, social services, housing providers, was seen as another important area, and residential bail programs addressing both the needs of individuals that could be kept out of incarceration and that are in need of housing. And we'll also hear more about that from Craig. So just to provide, as I said, that Craig will provide a bit more information about this afterwards, but just a bit of context. The Bail Verification Supervision Program, it's a low-cost, effective community alternative to jail. It's for individuals that do not have a viable surety. And the outcomes are very positive. So we have 96% of clients that are in the BVSP attend all court dates. So that's preventing those failure to appear charges. A vast majority complete the program without any breaches or new charges. And clients are connected to social and health services that address some of those unmet complex needs. So this is a really positive program that provides both supervision and access to really important community-based services. And the bail beds as well, this is for individuals that are in the BVSP program but do not have housing, and this has the opportunity to provide supervision, access to supports, and shelter for individuals. So flowing from the survey findings and the focus groups, we identified three main recommendations that came from this work. So the first is around bail programs. This speaks to expanding BVSP funding, expanding funding to the Bail Verification Supervision Program, which would allow for more intensive case management to meet those increasing complexity of needs. It would allow them to expand caseloads and expand geographic coverage across the province. While the program exists in many places across Ontario, it's not everywhere, and this is something that could be expanded with increased investments into the program. We also emphasize the importance of Indigenous-led programs, so making sure there's culturally appropriate supervision and support, especially in Northern Ontario, and to expand bail beds. Right now, bail beds exist only in 5 or 6 sites in the province, but the need is much, much greater. We know that the homelessness issue is in the province is like it is in elsewhere in Canada is increasing, and that's intersecting with the bail and remand system in significant ways. And so the bail bed program would really benefit many, many communities across the province. And that's just a quote from one of the respondents speaking to the importance of bail programs. The alternative often is that individuals are released to surety supervision, but sureties are often a family member. They're expected to sort of police an individual while they're in the community, ensure that they're being monitored and following their conditions. But a program where there's a trained caseworker that can provide that supervision, but also provide access to services and supports and the case management can be much more effective. So the second recommendation is around, is around interagency collaboration. So this is recommending an approach with cross-ministerial funding and support that really looks at integrated care for individuals. Individuals coming into the system with complex needs are having to access sort of multiple different points of care in different systems and falling through those cracks. And so this recommendation speaks to a bit more collaboration across the sector and across different systems so that an individual doesn't have any wrong door. Whatever service or system that they enter from, they can get the wraparound supports that they need. And this was also speaking to information sharing. So looking at police, housing providers, service providers, having more information sharing so that they're able to provide the appropriate care to individuals that interact with various stakeholders in the system. And the last recommendation is around court modernization. So this is a couple different areas, expanding specialized courts. So right now in Ontario, we have mental health courts, drug treatment courts, Indigenous peoples courts, and these are for specialized populations and can focus on specialized needs. This would be looking to expand and continuously improve these courts to make sure that they're achieving the outcomes that they're intending for these individual populations, and embedding court workers in courthouses. So a lot of people, especially those that are dealing with complex issues, come before the courts and have trouble sort of navigating accessing help, accessing where they're supposed to go, what other services are available to them. And oftentimes, they might find a John Howard worker, maybe a bail worker, ask them. But I think, formalizing this support, ensuring that there are court navigation staff in each courthouse would really help with efficiency of court processes and also ensure that individuals are accessing the type of services that are available to them and that they require. And then looking at the use of judicial referral hearings to improve efficiencies in the courts. So we're seeing that it's taking longer for cases to move through the courts. And a lot of these cases, as I mentioned in the beginning, are administration of justice offenses that often do not involve victims or significant harm. And so judicial referral hearings are ways to address those more minor cases without an additional laying of charges, without a number of additional court dates. So you can improve efficiencies and address those issues much faster in the system. So overall, these recommendations are meant to improve the system in a couple different areas. One is around resource efficiency. Right now, individuals with complex needs are cycling through the system. They're cycling through incarceration and homelessness, often relying on emergency health services. And so if we can get folks the support that they need, we can reduce costly emergency interventions and crisis responses and allow the system to better focus on serious cases as it was designed to do, and not on these sort of more minor cases really relating to complex health and social issues that aren't being met. It would also improve outcomes for individuals. They would receive coordinated, comprehensive support and have some of their root issues addressed. And this would also reduce recidivism with the appropriate care. And all of this has not only an individual impact, but a community impact. We will see overall enhanced long-term community safety and stronger partnerships across different sectors. So just wrapping up, this is looking at building out our community-based supervision and support infrastructure. We know through this research, 90% of cross-sector professionals agreed on some of these recommendations to improve the community supervision infrastructure in Ontario, noting that as a number one solution to reducing the remand population. And this requires sustainable support and funding and collaboration across sectors. And obviously solutions must address systemic racism and overrepresentation, because we know that the folks most impacted by the issues around bail and remand are there's overrepresentation of Black and Indigenous folks, of individuals with mental health and substance use issues, and solutions must recognize those disparities. So that's it for me. I will turn this over to Craig for the next part of the presentation.
Thank you, Safiyah. Go ahead, Craig.
Yeah, I'm just going to get my screen shared.
Okay.
And can everyone see that? Perfect. Yeah, so I'm Craig Santos. I'm the coordinator for the Bail Beds program in Ottawa. And I'm going to be talking mainly about the Bail Beds program, but I will be touching just on the bail supervision program, just because the programs are very closely aligned, and all the clients on bail beds have to be on bail supervision as well. So in order to be eligible for the bail supervision program, the clients must have some kind of status in Canada. That's required by our funders at the Ministry of the Attorney General. They can either be a Canadian citizen, a landed immigrant, a refugee, but they must have some kind of legal status. So we can't take anyone who might be either on a work visa or a student visa. They cannot have a surety. So as Safiyah mentioned, there's two ways maybe people can get bail. Generally would be either released on their own recognizance, or more commonly to a surety, which would be either usually a family member or a friend. Also, too, they have to be willing to participate in the program, the bail supervision program, and have the ability to understand the expectation of the program. So they have to know what they're getting into and what's required of them for the participation. Also, too, it is taking consideration the number of convictions for failures to comply with conditions in the past. So in Ottawa, the threshold would be 3 breaches in the past 4 years. So if they had 3 convictions for failure to comply in the past 4 years, unfortunately, they wouldn't qualify for the bail supervision program, but they would still qualify for the bail beds program. And I'll be discussing that a bit later in the presentation. They would also have to have a verifiable address. So it would be somewhere they're living, and that could be a shelter. In terms of the referral process, the referrals would generally come from somebody in the legal community. So generally either duty counsel, a counsel, whether it's funded either privately or through legal aid, and also the Crown attorneys. If a client is deemed eligible for the program, the next step would be the bail supervision intake supervisor would actually meet with them in the cell blocks just to do the intake interview with them. And then once they're accepted, they would be released to the program, and it would actually be on their conditions where they would have a set time where they'd be required to have their first meeting with the bail supervisor. And then again, that's actually listed on their release conditions. During the meetings, the bail supervisors would go over the conditions of the clients, make sure they're aware of them all, they understand all the conditions. They would ensure that they were aware of the next court date and also when their next bail supervision appointment would be. In addition to, they also have the option too of referring the clients to different programming, whatever basically referrals they think might assist the clients. They can do. We're lucky in John Howard, Ottawa, where we are a fairly big John Howard affiliate. We have a number of programs. So internally, the bail supervisor would have the option of referring the clients either to employment services, some educational upgrading programming, housing support, anger management, crisis intervention services. And the nice thing is that the bail supervision program is based out of our main office, and all these other programs too are also based out of the main office as well. So they can go to their appointment and then also do other things, kind of like a one-stop shop, I guess you could say. Additionally, too, we do have the option of referring clients to outside programming, depending what they're looking for, what their charges maybe were, or what may help in their court process. So that could be New Directions, which is a domestic violence program, various drug and alcohol programs, the Detox Center here in Ottawa, substance use services. Maybe they might even need something a little more intensive and go to one of the day or residential treatment programs, and also make referrals to mental health workers and various counseling supports too. Okay. Unfortunately, the part of our requirement is that we are required to breach clients under certain circumstances. The first and probably the main one would be if they miss 2 consecutive appointments. So how the supervisors do it, if they miss the first appointment, they would send the client a letter. It would explain that they had missed their first appointment, and it would give them their second appointment time. If they missed that second appointment, then they would be obligated to report that to the police. And it would be up to the police if they wanted to lay a breach charge on that. Sometimes they might give a little leeway, give the client another opportunity to attend. Other times they might just proceed with the breach charge. Also, too, if a client is not residing at the verified address, so if it comes to light that the client isn't actually living where the bail supervisor thinks they're living, that would also be a requirement that we'd have to breach them for. And additionally, to just like the bail beds program, if we became aware if there was any additional breaches of the release conditions, we would be required to notify the police, and that can either be done through the phone, email, or more commonly, actually, the police in Ottawa have a portal we can use that it's pretty quick. It walks everyone right through the process. In terms of staffing, there is one court intake worker here in Ottawa. So he would be required, he would be the person, if someone is referred to the program, he would be the first point of contact. He would review the documents just to make sure they were in fact eligible for the program. And if so, then he would proceed with the intake interview. We also have a WASH court worker. So that stands for weekends and statutory holidays. So even if, say, someone's taken into custody on the weekend, rather than have to wait till Monday to see a judge or get in front of Judge or JP, they can do that on the weekend and potentially get released that same day. There's 6 bail supervisors here in Ottawa. There's 2 more in Cornwall, another one in Perth and Pembroke. We have 2 enhanced mental health bail supervisors. Initially, we started with 1, but we recently got the funding for a second about a year ago. Additionally, there's the bail bed programs here in Ottawa that with John Howard, that's the one I manage, and then there's also a women's house too that's managed by E. Fry. And there's also too an Indigenous People's Court bail supervisor too. So if the client did identify as Indigenous, they would have the option of proceeding with the Odawa bail supervisor. Odawa is a Aboriginal support that helps the clients here in Ottawa. So one of the key aspects is in 2017 is the Ministry of the Attorney General was sort of looking at things and just sort of looking at how the bail system could be improved. A big catalyst for that was the John Howard Ontario team. But probably, as Safiyah mentioned, one of the biggest concerns was just the overcrowding in institutions. They're pretty dire conditions there. I've heard countless horror stories from our clients over the years about how there's overcrowding, it's filthy, just dealing with higher, like often they're bunked with higher risk inmates. So that was one of the main concerns that they had. Also, too, that there was the need to just release more people to the bail supervision program. There just wasn't enough space in the institutions for them. The need, too, that there was identified that there was more mental health services required for the clients. requests for the residential supports for bail clients, such as the bail beds program, and also to a request for to have more access to Indigenous bail supervisors from the community for the Indigenous client. And this led to, in my opinion, 5 key outcomes. The first was that they did increase the funding for mental health bail supervisors. So these are specific bail supervisors that can assist the clients with mental health, with more severe mental health issues. The wash court, which again was the weekend and statutory holidays, which didn't exist before. And the implementation of rural offices. So what was happening before was it wasn't really fair. If you were living with in a bigger city, they would be more likely to have a bail supervision program. But if you lived in a smaller town or smaller city, more in the rural districts, you wouldn't have that option. So if someone was released and they didn't have a surety, the chances of them getting bail would be very much reduced. Also, too, the Indigenous, as I mentioned before, the Indigenous bail service, that was part of the enhanced funding as well. And last but not least was the bail beds program, which I'm actually going to use as a segue to talk about my program, the bail beds program here in Ottawa. So we have been open since 2017. We're coming up to our 9-year anniversary just next month. And the mandate of our program is to provide community-based residential supervision for higher needs individuals that would likely otherwise be held in custody pending the resolution of their charges. So essentially, we'd be sort of like the last stop for people looking for bail. If they didn't have a surety or didn't qualify for the bail supervision program, for one reason or another, either they didn't have an address or had too many breaches, they could apply to our program here. And we do give particular consideration to the more vulnerable populations, such as the Indigenous people and people with mental health and addiction issues. Specifically with the Indigenous clients, we do give them priority. So if someone's on our waiting list and identifies Indigenous, we will bump them up and we'll try to get them in as quickly as possible. Okay. Some of the program features, much like the CRFs, we are required to be staffed 24 hours a day, 7 days a week. That includes holidays, whether it's Christmas or any other day. And the staff are required to be on site at all times and awake at all times. Additionally, we have a 10 o'clock building curfew, which I'm going to get into in a little more detail in the next slide. The ability to provide support for mental health and addiction issues, just like the bail supervisors. And again, just like the bail supervisors, we are required to, if we become aware that the clients are breaching any of their court mandated conditions, we are required to report that as well. All the clients here too are required to meet with a John Howard bail supervisor at least once a week. Every third meeting at least has to be done in person. The rest can be done over the phone. And additionally, we do offer our clients the opportunity to participate in other John Howard programs and services, as well to be connected with any of the outside programs as well. So some of the program aspects, we are a 12-bed facility. Currently, we originally started with all 12 beds designated for clients on bail supervision. Unfortunately, the funding wasn't the greatest over the years, so we did have to diversify our funding, and we actually found 3 new funders. So currently, we have 9 beds designated for the males here in Ottawa. And the EFRI, as I mentioned, manages the women's program, and they have 7 beds for female clients there. In the event that a client identified as transgendered, they would have the option of applying to whatever program they felt more comfortable at. One of the nice aspects of this program is we are a duplex style house, so there's actually 2 sides of the house. And the nice thing with that is it gives us 2 separate kitchen areas, 2 separate. Sorry about that. Oh, very sorry about that. You can tell I'm not too technologically savvy. Yeah, as I mentioned, we do have a 10 o'clock building curfew as part of the rules here. Any time of a client, this is something the Crown specifically asked for in Ottawa. If a client's not back by 10 o'clock, we are required to report it. We don't have any leeway with that. We would prefer to have some kind of thing, and often to the Ottawa Police, sometimes if we do file that breach report and say a client's 2 minutes late, they'll kind of ask us, why you really expect us to breach a client if they're only a couple minutes late? We just explain to them the reason we do that is because we are required by the Crown to. But generally speaking, it's very unlikely the police would breach somebody for being late for their curfew, especially if it's only by a couple minutes. It's only if it becomes an ongoing issue with them. And usually the police would check in with us too, just to make sure, see how the client's doing. If a client's doing pretty well aside from their curfew issues, they'll usually give us the opportunity to keep working with it, and they do take the feedback from us. Additionally, too, the clients are required to check in with the staff each day, and that's to be done before leaving for the first time each day. We do that for two reasons. Number one, it gives us kind of the opportunity to see what the clients are up to, and it also makes sure that we're having daily contact with the clients and just knowing what they're always up to. We don't allow any drugs or alcohol on property, but we don't have any rules against what the clients do off property. We definitely don't encourage it or condone it, but if a client does, we understand that clients come to this program, they are likely going to have some kind of addiction issues. So if they do, we're willing to work with them. It's more if that the behavior when they're using or under the influence negatively affects their behavior around the house, then we'll definitely intervene on that. In terms of staffing, we are single staff for the most part. We do have a residence coordinator. I'm the coordinator. I work during the day. Additionally, there's evening support workers, overnight support worker, and we do have a full-time caseworker. We actually didn't have that initially. It was just me here during the day trying to balance the admin duties and being a caseworker. But just with some funding we got from other programs, we were able to add another caseworker. Additionally, too, as I mentioned, we are required to be staffed 24 hours a day. So we do have a part-time staff that would cover the weekend, holidays, and any vacation or sick days for that the full-time staff can't work. In terms of the referral process, it's very similar to the general supervision program. The defense counsel would submit a referral form to me along with the charge sheet and the criminal history. And then if the client does meet the eligibility requirements, I would set up an assessment interview. I'll get into a little bit more detail on that. And then if the client is accepted in the program, I would notify the bail supervision program and he would do the intake with them as well. So again, they have to be accepted into both programs. And then at that point too, our intake worker would provide the defense counsel with the verification report and the acceptance letter, which basically just explains that they've been accepted into both programs and what kind of conditions should be on the release orders. As I mentioned, all the clients that get accepted to this program do go through a rather thorough assessment interview. One thing we realized when we first opened is that it is important to screen the clients. When we first opened, we did have a lot of issues here. There was physical fights between the residents. We had an overdose. So we really realized that it was important to screen the clients. And once we tightened up our screening protocols, a lot of the issues that we had to deal with initially went by the wayside. So prior to COVID, I did most of the assessment interviews in person, either at the institution or at the cells at the Auto Courthouse. But since then, the landscape's kind of changed, and it's just cheaper and easier for the clients if we do them over the phone. The interviews tend to take about 25 to 45 minutes in length. They're pretty thorough, as I mentioned. So sorry, I don't know why it keeps skipping ahead. And we basically are looking to make sure that they can follow our house rules, their court conditions, and get along with the other residents. So we go in depth with their substance abuse issues, their mental health issues, what kind of community supports they've had, past accommodations, if they've ever lived in a program like this, and just generally making sure that they're suitable for a program like this, especially because, again, it is a communal environment. Some of the key challenges we've had over the years has been exiting the residents due to problematic behavior. And this is really an issue because the clients, it's actually tied into the release conditions on when they're on bail that they have to live at this program at this address. So one of the issues we have is what do we do if, say, a client's creating a toxic environment to the residents, either being a bully, they're not listening to staff, they're just being generally disrespectful to community members. Because it actually is tied to their conditions. I mentioned they have to live at this address. And so we can't just say we're withdrawing support and sending them to a shelter because then the Crown's going to ask, well, why are we sending clients to you if to be supervised if you're just going to turn around and send them to shelter where they're not getting any supervision at all? So we don't really have a mechanism right now for withdrawing support. It is something we've been working on over the years. We've met with the police, with judges, the Crown, you name it. Nobody really seems to have a perfect answer for us. So that is, again, why we take the screening so seriously. Additionally to incorrect wording on the bail conditions, sometimes it happens where even though the clients are required to live here, and it's actually required by your funder, there might be a court clerk that makes a typo, or for whatever reason, the conditions to live here and follow our house rules don't make it onto their conditions. So that makes it very challenging us to deal with it. And it always seems to be when that does happen, it's always the more higher risk clients. It's not the more easygoing guys for whatever reason. As I mentioned too, interpersonal conflicts between residents. Probably the most common thing, because we are a communal environment, is that one resident, say, would be eating another resident's food, and it can deal with some interpersonal conflicts. One thing we've noticed though is it's really funny how the guys can maybe at each other's throats one day, but then within 24 hours, they've already hugged it out, they get along, and things tend to go back to normal pretty quietly. Like anytime things get kind of hectic and crazy around the house, usually it gets resolved just within the next 24 hours, and it's almost like a little too quiet at that point. And the last one is the opioid crisis, where just with fentanyl and syringes, we actually no longer accept clients on fentanyl just because it is for concerns with the staff safety. And also, too, it is very difficult to work with other clients if using fentanyl. It usually results into them just being incoherent, not listening to us, and leading to other issues with the other residents. One of the nice things about this program is we do actually have access to a mental health worker. There's a mental health worker who's tied directly to this program, both for the men's and women's program. And some of there is a very long waiting list for CMHA, especially in Ottawa. But the nice thing is if a client gets into this program, we can usually refer them to a CMHA within the first week or so. It's funded by the Ministry of Health. So even though our funding comes from the Ministry of the Attorney General, we do get funding for a mental health worker through the mental health Ministry of Health. And the nice thing is, even after the clients leave here, they can still work with CMHA down the road too. So they have ongoing support. The CMHA worker actually comes to the residents. She'll meet with them on a weekly basis. And the information that's shared with the CMHA is confidential. That was one of the things when we first opened, is that had come up was that the clients kind of understood that they knew we were here to help them, but they also knew that we had an obligation to report things. So that was sort of the missing component for our first year. And then after that first year, we did get the funding for the CMHA. So that's it for my presentation. If anyone does have any questions, if anyone's watching record, I've got my contact information there. But also too, I'd be happy to answer any questions too that might be coming up from the chat.
That's terrific, Craig. Thank you so much. I assume that my colleague Rhea Higginson there is collecting some questions from the chat. I have a couple of questions though. One is the reintegration challenges. I recently watched a videotape of a prisoner being released from an Ontario center in December. He had been arrested in August. He was a Black man, and he was, in his running shoes, no jacket, no gloves, and it was darn cold out there. He was subsequently arrested 2 hours later for violating some conditions on another order. He happened to have been sleeping on a park bench at the time in, I guess, an area where he wasn't supposed to be. So the people who are coming out after 6 months or even a long period are kind of disconnected, right? They've lost their apartment, they've lost their jobs, they've lost their. How do we support the reentry? If they're coming out of a federal institution, I happen to know they've got a reintegration plan, or at least they should have a reintegration plan, and a few things are mapped out for them, but they can be very suddenly just sort of released from remand with no supports.
Yeah, absolutely. And that's one of the things I find very frustrating is it does even happen to some of the clients that are released to us to this program here, where it can be the middle of winter and basically they're released with whatever they happen to be arrested on. So if they were arrested in the summer, they might just be in like a skimpy jacket and not much else. And we've actually had it where the clients have been released later at night. No bus directions or anything to get here. And we've had a few that actually had to walk in the middle of winter in their spring jackets. That's one thing I've actually been working on. We're fortunate enough in Ottawa, we have a discharge planner at OCDC with John Howard.
Yeah, good.
Lucy Carrier. And so often too, if we know somebody's coming and they don't have access to that, we will try to make efforts. We'll try to get some donations for them and make sure they have the bus tickets to get here. But it is an all too common problem where people are getting released, like you said, just with nothing, with nowhere to go. Basically, they're done. They either get released from their sentence, very little support, and once they're released, there's nothing that follows them. Where say if a client's on parole, at least then they have that at some point where they're still being seen in the community. But it is an issue that I know that we've been trying to deal with here in Ottawa, and I'm sure across the country, it's probably an ongoing issue as well.
Yeah, I think it's a real challenge. Yeah, Safiyah.
I can just add to that too. I think some of the other work that we're doing around the policy pieces is that housing aspect. So bail beds are a great program that exists to help people that are on bail. We're also, advocating for a system of transitional housing across the province, so people do have somewhere to go. Because again, like you illustrated, Catherine, if people are released right out onto the streets, which happens very frequently, it's really difficult to follow conditions, to follow through on any referrals that they might have been given while they were incarcerated. And then we're seeing people just cycle through at great cost to themselves and the system. So I think advocating for a place to land is a really important piece as well.
I should mention too, we actually just got a new program here in Ottawa. It's called the At the Gate program. It's actually funded by the Ottawa Police. And what it is, it's called At the Gate because it's literally a worker will meet with the client at the gate when they're released. So usually if they're already referred to clients, and then they're automatically, as soon as they're released, they're connected to the John Howard resources. And as I mentioned, we do have 3 different funders here aside from Meg, and we actually have a bed with them too for At the Gate too. So it is an option. It's really just a drop in the bucket. It's not really much, but at least it's something, and it's a start. It's showing that at least they are taking it seriously.
Yeah, that's good.
So we do have a number of questions flowing in. I don't know if we'll have time to get to all of them, but we'll do what we can. So a question from Mary. If a person is eligible for bail beds, but your program is full, do they remain in custody until a bed is available?
That's right. Yeah. So we do have a waiting list. It's usually pretty full, but they do have to wait. And sometimes it can be a lengthy wait. Generally what we see though is, and this is one of the unfortunate things, is often it's almost like an ultimatum for them where they have a choice to make. They can either take, say, a plea deal with time served and get released maybe like without having to wait, or if they really want to fight their charges, they can wait, but they'll have to wait till a bed comes available. And that means sometimes it could be as long as 2 to 4 months for that. So it is very unfortunate. It's basically they have to decide if they want to get released or get that criminal record. So it's very frustrating.
I think that's an important point. I mean, the conditions there are prompting people to plead guilty to perhaps offenses they didn't commit in order to get a bail bed or out. Yeah,
absolutely. Yeah.
What is the average stay in your program?
That's a great question. So it is actually tied to the release order. It's something that the Crown from Meg had actually, the Crown Division from Meg actually requested, is the clients are required to stay here usually up until all their criminal matters are resolved, unless they get a bail variation through the courts. But that has only rarely happened. I think we've only seen it happen maybe 2 or 3 times over the 9 years we've been open. So generally speaking, it would be as long as it takes for them to resolve everything. I would estimate the average length would be about 9 months or so, though. But we've had some clients here as long as 4 years, believe it or not.
What does JHS think the impact of Bill 75 will be on bail programs?
Yeah, so this is the proposed legislation looking at introducing cash bail. I think that's the one that's being referred to here. And I think what we're seeing, and as we noted in this presentation, people are often incarcerated due to complex needs, often lacking social support in the community, lacking somebody that can come forward as a surety for them. And so I think with the introduction of cash bail, this would result in more people being denied release if they cannot afford to pledge money up front for their release, or if the sureties that they could find that would be eligible can't afford to pledge money up front. And that would disproportionately impact those that are lower income, that Black and Indigenous populations, people with mental health issues, that are dealing with these complex issues in the system. So I think we are definitely concerned from that perspective, and really trying to emphasize the importance of effective community-based supervision options to address some of the issues we're seeing around over-incarceration and burdens on the system, which are affecting, as I mentioned earlier, police, courts, and corrections across the board.
So we do have a comment from Lindsay, and I'm not going to read the whole thing, but she was talking about the conditions of confinement for people in remand. Do we have anything more we want to say about that? She felt like we didn't touch on it very much.
I think, if I may, I think I know the Lindsay that you may be referring to, who's a voice for people with lived experience. And I think it's, we had tried to get Soliman Fakiri's brother to speak about some of the conditions, because it's particularly bad with people who are experiencing mental health issues. They're coming into the prisons with substance abuse issues. I know that Safiyah and John Howard Ontario and John Howard Canada recently participated in a coroner's inquest where a great number of people had died as a result of overdoses in the remand system. It's very perilous. It's very violent. It's bad. And Lindsay is probably right that that element is probably best conveyed by someone with lived experience. Maybe we'll find some time, Lindsay, and somebody from your council can talk to us about what they've experienced, because it is horrifying.
Now this one seems to be maybe specific to Toronto, I'm not sure, but the question is, if beds are full, are clients needing bail referred to safe beds or central intake? So many clients experiencing homelessness and don't even know about options like the Toronto Bail Program or John Howard Society, and then the issue of needing an address. I don't know of those programs specifically. Are either of you familiar with them?
I'm not sure if an individual needing, I know in Toronto there are some limited beds available, but I don't believe, I think those are with a different organization focusing on Indigenous women, if I'm not mistaken. So I think again it goes to sort of the need across the province for bail beds and for somewhere for people to go if they are no fixed address or experiencing homelessness, to ensure their release where it's appropriate. And we just don't have the adequate number of beds across the province. They're only in a couple of communities, and it's nowhere near meeting the demand. So we definitely need more options.
Is there any particular focus on Black offenders? This question is coming from an individual who attended at some meetings about the Black Justice Strategy, and having previously worked in a CRF, she's interested to know about what is being done for the overrepresentation of Black offenders and or Indigenous and people.
Yeah, I think from a provincial standpoint, and I can let you jump in, Craig, if you have anything to add, but a provincial standpoint, absolutely. We're definitely highlighting the overrepresentation of Black and Indigenous folks within the system, and the need for appropriate programming, culturally safe and relevant programming, and to ensure that we're addressing those disparities. So that's definitely a focus area.
Yeah, and I could echo that too. I know in John Howard Audit specifically, it's something that we are really trying to address. There definitely is some gaps in the system, and we've seen some marginalized communities that are overrepresented in the system. So we do, I know from my perspective here at the Bail Beds program, we do everything we can. If we can identify those clients, we will try to get them into the program as quickly as possible.
We probably have time for just a couple more. So a question, Craig talked about being obligated to report people to police for minor breaches. Are there other ethical difficulties that have caused John Howard Society, Ottawa or Ontario concerns?
I think in terms of the breaches, that really the only one that we're required to would be mainly about the curfew violation. Everything else we try to handle in-house. My preference is to always deal with, like, rather than involve the police. If someone's say not following our house rules, I'll always try to deal with it here just through one-on-one meetings. And usually we are able to address it without bringing in the police. Um, in terms of the ethical dilemmas, I think it's more just sometimes we see it where it really can be arbitrary with say who the investigating officer is. So everyone who's on bail in Ottawa anyway would have an investigating officer. That's a member of the police that would be specifically in charge of their file, and it would be that one person that's responsible for filing a breach charge. So what tends to happen is if you can have two clients both late at the same day for the same time under the same circumstances, and one might get breached, and so it's very arbitrary. So that's one thing we find very frustrating. There's not much we can really do because it's so ingrained in the system. So what we encourage the clients to do is just make sure that they're aware that this could happen. And as long as they worry about their following conditions and worry about making sure that they're always back on time, it'll reduce the chances of that happening, especially if we identify someone that we know was a strict investigating officer. Usually if that happens, if say someone's late, even if the police breach them, I'll still give them a second chance, or they'll have to go through a bail hearing again. But I think that's kind of silly. If a client's doing well here and other aside from the curfews, we feel we can manage them, we will take them back. But we'll also make sure they know if they're late again, the same thing's probably going to happen. And there's not much we can do about that. It's in the hands of the police.
Are there bail bed programs in other provinces?
Um, I know that there's been some over the years, and some of them might have different models. I do know Winnipeg had one at one point when we first opened, but I think they've closed down due to some funding issues. And even here in Ontario, I think there's only really three cities that have the bail beds programs. It's us, Thunder Bay, and Barrie. Ottawa and Thunder Bay, we both have standalone buildings where they're separate, speaking for other clients, but the ones in Barrie are just beds in a shelter. And I know talking to the managers from those over the years, they've had a real issue because there's so many other issues just with being in the shelters where the drugs and alcohol are constantly in their face. So it really reduces their chances of being successful. But it's something I know the province is looking at expanding, but just I think a big thing is they're just not willing to fund it
Yes.
at this time.
I
So
think,
because of that,
if
it's hard to implement the programs.
Yeah, a lot of John Howards from other parts of the country are quite interested in this model and implementing bail beds. So John Howard Ontario is very generous with sharing their research and the data, which indicates that this ultimately is saving provincial governments money. So I think it's certainly the time is right to lobby hard to get equivalent programs in other provinces, and certainly Ontario is quite special in having such a developed program. But as I'm sure Safiyah and Craig would tell you, it's not enough. There needs to be more resources directed to this to get as many people out of the awful remand conditions as possible. And there is a real class and race bias in that this is all contingent on ability to get a surety. So we're trying to, equalize some of that class bias in the justice system by having bail beds and bail programs. Sorry.
Speaking of sureties, this wasn't really a question, but there's quite a little chat going on in the chat window about sureties that take advantage of people and who ask them for money or will refuse to sign as a surety without by exploiting the individual that is needing the assistance. I don't know if you've ever had any experience of that. Certainly there are people in the chat who have.
That's pretty ugly.
Yeah, and I think there's, as we heard in the consultations too, there's lots of concerns across the board about sureties. You mentioned exploitation. That's definitely that's a huge concern. Also, just having to rely on a family member and put them in a really difficult position of having to monitor and their loved one in the community, it can be really difficult. And the benefit of having a caseworker and a program is also the connection to support. So somebody to, like Craig, to sit down and work with you and build out a case management plan and connect you with the appropriate supports to address your needs is a great benefit of the program versus the surety releases.
I think that's everything.
That's terrific. I really want to thank both Safiyah and Craig for their very informative presentations, and I hope it inspires a lot more efforts or willingness to try some alternatives to remand for some of the needy people that we see in there. Thank you very much. Appreciate it.
Thanks so much.
Happy John Howard Week. Take care. Bye now.